Good afternoon, everybody, and welcome to the Children's Law Centre and to this webinar on children's rights and the future of religious education in Northern Ireland. My name is Eamonn McNally. I'm the Senior Solicitor at the Children's Law Centre, and I'm joined today by Steven McQuitty KC. Stephen, you're very welcome to the Children's Law Centre.
Thank you very much, Eamonn. Good afternoon.
For those of you that are non-legals and aren't aware of Steven, he's a very experienced KC who was called to the bar in 2005 and took silk in 2024. Steven has considerable experience in bringing and defending judicial review applications across a wide range of different legal contexts, and he was the barrister who represented the child in the case of JR 87, which is going to form the basis of our discussion today. So just by way of background, the JR 87 case was essentially begun in the High Court and appealed all the way to the Supreme Court. The issue in the case was whether religious education and collective worship provided in a school in Northern Ireland were contrary to Article 2 of Protocol 1 of the European Convention on Human Rights when read together with Article 9 of the ECHR as incorporated by domestic law. The child in the case was anonymised to JR 87 and attended a grant-aided controlled primary school in Belfast. As part of the curriculum, the child participated in non-denominational Christian religious education and collective worship. The child's parents did not wish her to be taught that Christianity was an absolute truth, and her father challenged the legality of the religious education and collective worship and sought judicial review against the Department of Education. Initially in the High Court, this challenge was successful, and the judge held that religious education and collective worship in the school followed the department's core syllabus. They were not conveyed in an objective, critical and pluralistic manner. Although the parents had a statutory right to withdraw their daughter from these activities, this right was not sufficient to prevent a breach of Article 2, Protocol 1 when read with Article 19, and it placed an undue burden on the child's parents, deterring them from seeking withdrawal and risk stigmatisation of the child. So the judge granted a declaration that the teaching of religious education and arrangements for collective worship breached the child and her father's rights. In the Court of Appeal, they upheld the judge's finding that religious education and collective worship in the school were not conveyed in an objective, critical and pluralistic manner. However, the Court of Appeal disagreed with the judge's conclusion that the parents' statutory right to withdraw their child was insufficient to present a breach of Article 2, Protocol 1. The Court of Appeal held that the existence of this unqualified statutory right meant that the state was not pursuing the forbidden aim of indoctrination. Further, the Court of Appeal very much doubted that fears of stigmatisation or of an undue burden on the child's parents would have presented itself in reality. The appeal was allowed and the application for judicial review was dismissed. Ultimately, the matter was appealed to the Supreme Court, challenging the Court of Appeal's conclusion that the statutory right of withdrawing the child from religious education and collective worship meant that there was no breach of Article 2, Protocol 1 when read with Article 9, and the Department cross-appealed, contending that the judge erred in failing to separately analyse and determine the claims made. The Supreme Court ultimately unanimously allowed the appeal and dismissed the cross-appeal. And that's what brings us to the judgment that we're going to discuss today. So Stephen, thank you very much for joining us today in this topic. We have a very broad audience for today's event of both educationalists, legals and interested parties. So really just to set the scene for us, for our non-legally trained listeners, could you outline the core legal issue at the heart of JR 87's challenge?
Yes, certainly, Eamonn. First of all, thank you very much for inviting me to along for this podcast. It's great to be able to talk about the case. It's a rare win, so it's lovely to be able to reflect on that. I should also say that I was one of the barristers involved, but at that stage I was the junior barrister, so I was led by an English silk called Ben Jaffe KC, very eminent English senior counsel. And we were instructed by Dara Mackin in Phoenix Law. So I was in the fortunate position in going over to London that I didn't have a speaking role in the Supreme Court, so I could fully enjoy the London experience without having to worry about getting on my feet. In terms of the core legal issue, well, that's really quite narrow ultimately in the end, which is it was accepted across the piece between the parties ultimately in the Supreme Court that religious education in Northern Ireland wasn't being delivered in a way that was critical and objective and plural. And the question was whether or not that scenario could be saved by the existence of a statutory opt-out where parents could obviously exclude or ask for their child to be excluded. And that was an absolute right to have their child excluded. They didn't have to do anything save for ask, albeit, as we'll probably get on to in our discussion today, there was a bit more nuance to it than that. So that was the issue. In terms of what the Court of Appeal had decided, as I say, they had upheld the High Court judge where he had found that, yes, when you looked at the core syllabus, it wasn't critical, it wasn't plural, and it wasn't delivered in an objective fashion. But what they held was, notwithstanding that didn't amount to indoctrination. And furthermore, the Court of Appeal said the parental fears about what would happen if they exempted their child would not likely have materialized, and therefore the opt-out was a complete defense to the claimed breach of the convention. And just for the non-lawyers out there, when I'm referring to Article 2 of the first protocol, I'll call it A2P1, and that's just the right to education. Tacked on to that, there's a second sentence to A2P1 in the European Convention, which is to protect parental convictions and beliefs, so that there is a right for parents to have their children educated in conformity with their own philosophical and religious beliefs as well. And that right under A2P1 has to be read alongside Article 9 of the Convention, which is really just freedom of conscience, religion and belief.
So, Stephen, you touched on Article 2, Protocol 1, and how it interacts with Article 9 in this context. And just to expand on that a bit, could you elaborate what respect for parents' religious and philosophical convictions require in practical terms to be carried out whenever a school or an education authority are looking at this judgment? Yes.
So respect is obviously potentially a fairly broad term. But what the Strasbourg case law establishes, and I'm referring to a case called Folgero, and for anyone who's read the judgment, they'll see that's the leading judgment in this particular area of the convention from Strasbourg. And respect means more than just taking into account someone's convictions or beliefs, and it can impose a positive obligation to, quote, take care that a religious education curriculum is conveyed in an objective, critical and pluralistic manner. Folgero also goes on to say that what the state are forbidden from doing is pursuing an aim of indoctrination. And in this case, in the JR87 decision from the Supreme Court, they effectively said that was just the other side of the coin. In other words, if education was not pluralistic, objective, and critical, then it follows that it amounts to indoctrination, and obviously vice versa.
In the case, did you then argue that the Northern Ireland core syllabus inherently failed this test, or that its delivery and practice didn't meet the standard?
Yes, but we didn't actually have to argue it in this appeal to the Supreme Court, because the High Court had established, on the basis of its assessment of the curriculum and allied with the arrangements in place for collective worship, that RE was not being taught in accordance with that standard. The Court of Appeal upheld the judge's factual findings on that particular issue. So they were proceeding from the starting point that, yes, we have a curriculum that is, if you like, suspect because it doesn't meet that convention standard under A2P1. And so that was the starting point for the Supreme Court. Now, the department had sought to cross appeal on a couple of issues. One of those issues was whether or not the High Court and ultimately the Court of Appeal were correct in reaching that factual finding about the nature of the delivery of the curriculum, but they had been refused permission by the Supreme Court on that particular ground. And so for everyone in the appeal, involved in the appeal, the starting point was there was effectively a problem with the curriculum in that it was not being delivered in a way that was critical, etc.
In the judgment, the term indoctrination comes up a few times, and it's a term that some people could find difficult to get the concept around. So, and the Supreme Court seems to discuss it almost in a neutral sense. So, could you explain a bit about how you framed the legal threshold for indoctrination, and essentially when you were looking at this and how RE is taught in schools? Well,
yes. So I think really carry on from what I just said, for the Supreme Court, indoctrination was simply education that was not critical, pluralistic, or objective. So in that sense, they were saying we are using the term neutrally simply to mean education that is not critical, pluralistic, or objective. Now, what we had argued, I can't remember how we formulated it in the Court of Appeal, but certainly when we got to the Supreme Court level, we had actually argued that there was some concept of like a spectrum in terms of indoctrination. So a syllabus might be more or less indoctrinating effectively. Thankfully, I suppose the Supreme Court had the good sense to cut through that argument and adopted a much more straightforward and readily applicable understanding to the term, which, as I say, is simply the other side of the coin.
Before I move on to my next question, I'd just like to remind everybody online, if you have any questions that you'd like to pose to Steven during the course of this talk, if you'd put them into the chat, we'll have time at the end for some Q&A. So feel free to pop them into the chat as we go. So Steven, well, most of us through our own primary school and through our own education experience have been in the situation where classroom teaching, assemblies and prayers have formed a part of the everyday school activities. Did you argue that the cumulative effect of these activities amounted to a form of indoctrination or even evangelism?
Yes, we did. We argued that you couldn't divorce the content of the syllabus from the context, the broader context in which the syllabus was obviously being delivered, which was in the particular facts of this case. And as you say, Eamonn, many of us who have been born and raised in Northern Ireland will have had that experience ourselves of Christianity effectively being assumed, not just in terms of the curriculum delivery that is delivered as part of education, but also as part of the wider life of the school in terms of ministers or priests coming into the school, nativity plays, prayers at meal times, and all of those kinds of things. So yes, we were saying that you couldn't assess the effect of the curriculum absent consideration of collective worship. They effectively were reinforcing each other, and that is actually reflected in the final declaration of the court, because it's important to note that the Supreme Court effectively adopted or endorsed the declaration that was delivered at first instance in the High Court, which found that the legislative provisions relating to effectively the core syllabus, along with, I think the phrase is, the arrangements in place for collective worship, give rise to a breach of both the child's rights and her father's rights as well. So again, the court didn't see that the two issues could be separated out from one another.
Yes, and part of the argument raised by the department seems to have been that the core syllabus is simply a Christian-focused syllabus rather than being anything more than that. Did that arise in the case at all?
It arose in the sense that at first instance there was an argument about whether or not the core syllabus did in fact offend against that convention standard of objectivity, criticism, etc. But it's in my view, trying to be as, obviously I was on one particular side of the argument, but trying to be as objective as possible. I would struggle to understand how anyone could read the course syllabus and not conclude that it crosses a line between teaching children about Christianity and teaching children Christianity as a religious belief. It's clear from the language used in certain sections of the course syllabus that some basic Christian principles and assumptions are effectively assumed within the syllabus, and that's not a criticism. As I say, that's just a fact as to how it was presented and drafted. And again, that's not surprising in that the people responsible for drafting the syllabus were the four main Christian churches in Northern Ireland, and obviously as Christian churches, they ordain Christian ministers and priests. They have a vocation to spread the word, as it were, so it's not surprising that the curriculum reflected that Christian belief.
Throughout the judgment, there's a lot of discussion around the right of withdrawal, and it's an issue that many of the people who are listening to this today may be concerned about, both as teachers, educators, and as parents. The Court of Appeal placed significant weight on the right of withdrawal. So why did you argue that this safeguard was insufficient, and was it a difficult hurdle to show to the court?
No, I mean, in some senses, the case in the Supreme Court turned on one word, which was capable, and I'll explain that in a bit more detail. So we argued that the right of withdrawal was insufficient, because the evidence in the case, i.e. the affidavit evidence filed particularly by JR87's father, established that the opt-out mechanism was at least quote-unquote capable of placing the parents under an undue burden. And if anyone has the judgment open or can access it, I'm referring in particular to paragraph 44 of the judgment, and I'll just read that out for the listeners. So here the court is summarising the nature of the evidence. So what the court records is that JR87's parents stated that exercising the right to withdraw her from religious education and collective worship was capable of placing an undue burden on them by A, the risk of exposing their philosophical but non-religious beliefs to the school and to the wider school community, B, the potential for conflict with the school in relation to alternative arrangements for JR87 if she were to be excused from attendance, and C, the risk of the school viewing them as difficult or awkward parents. And they considered that these matters not only placed an undue burden on them, but also had effectively a deterrent effect on them, persuading them that it's not worth seeking to have their child withdrawn. Now, what is important to note is that in the High Court, the judge in the High Court, Mr. Justice Colton, as he then was, found that those concerns were quote-unquote valid. And that's important for listeners, particularly listeners from a non-legal background, to appreciate that that was a factual finding by the High Court judge. And what was unusual about how the Court of Appeal dealt with the case was that they departed from that factual finding, and they did so for really a couple of reasons. Firstly, they said, well, the child was never actually excluded, so it wasn't actually tested out, as it were. And in any event, even if they had excused the child, the Court of Appeal considered that it was unlikely that effectively their fears about stigma and all of the rest would have materialised. And what the Court of Appeal said was that the parents had to establish that their concerns about excusing their child were, quote unquote, objectively made out. And that was the test that they had applied in the Court of Appeal. So it was a sort of technical legal point then taken in respect of the appeal, because what we said is that the Court of Appeal were not entitled to depart from a clear factual finding rationally based on the evidence before the trial judge. And that's, there's a Supreme Court authority from Northern Ireland actually called DB, which says really that appellate courts, generally speaking, should not depart from the factual findings of the first instance court. And again, for those listeners that have a copy of the judgment, you'll see how this is dealt with. It's a pretty important part of the judgment at paragraphs 127 and 128 of the judgment. And what they say at paragraph 128, for example, is that the Court of Appeal fell into error in departing from the factual finding made by the judge. The judge made a factual finding that the concerns raised by the parents in relation to exclusion are valid. And then the Supreme Court goes on to say, applying the essential legal test, it is only in exceptional circumstances that an appellate court should reverse a finding by a trial judge on a question of fact. The Court of Appeal was not justified in departing from the judge's factual findings by holding at paragraph 100 that it was not satisfied that the filing of an exemption would result in stigma. And so that's how the issue was then presented to the Supreme Court. We were saying Court of Appeal were not entitled to depart from the clear factual finding of the trial judge, which was clearly based on the evidence and a rational conclusion for the trial judge to reach. And so that was that then led into, okay, if one considers that those concerns to be valid, and if that is the factual finding of the court, how does that then interact with the test to be applied in respect of opt-out mechanisms, which we might come on to?
Yes, because one of the thoughts that came to me from when I was reading the actual judgment is the difficulty for schools, the actual practical difficulties of when a child is withdrawn, that there will have to be alternative arrangements put in place for that child. There's obviously a resource issue attached to that.
Yeah.
And there's also the burden on the school of trying to make sure that the child doesn't, in fact, become stigmatized in the way that the concerns were raised.
Yeah.
And it's something I'm sure that people who are tuned into this are concerned about because it's their everyday working lives. So it's something, I suppose, that will have to be thought about as we move forward. The other thought that occurred was that when we looked at the right of withdrawal, it seemed to be essentially moving the responsibility away from the state towards the parent. And is that something that was of concern to the family in the case?
Yes. So the right of withdrawal effectively, in our argument, put parents in a position where they would effectively have to sort of discuss and negotiate with the school about their objections, if you like, to the status quo. And inevitably that would involve, whether expressly or implicitly, some disclosure of the contours of the parents' own beliefs about what they might find objectionable or not objectionable. Another important point to remember about this particular case was that the parents were actually advocating for religious education for their child. So they were from a non-religious background, worldview themselves, but they recognized that having an understanding of religion, having an understanding particularly of Christianity, is very important in Northern Ireland. Obviously, Christianity has been the dominant religion in Northern Ireland for a very, very long time, in the island of Ireland for, 1,500 years or so. So you can't really understand Irish history, culture, etc., without understanding religion. The parents recognized that and said, look, we want our child to have a good religious education, but what we want is for that to be a religious education, not effectively a form of evangelism.
Just looking at the actual right to withdrawal, is there a legal distinction between a theoretical safeguard and an effective safeguard when we look at that?
Yes, and one of the fundamental principles that human rights lawyers learn about the convention before you get into looking at any of the substance of the convention rights themselves, one of the basic principles that the Strasbourg Court always adopts and trots out with regularity is that convention rights are meant to be practical and effective, not hypothetical and illusory. And so in this case, the court was keen to ensure that the convention rights under A2P1 actually had some teeth and could be given effect in our domestic sphere.
Just looking at the child themselves, you're at the Children's Law Centre, so we're always going to focus on the rights of the child. The significant sort of under the radar thought of the judgment is that the child themselves enjoys the right to protection of their own religious beliefs under Article 2, Protocol 1. Do you think we're moving to a situation where perhaps a child could legally exempt themselves from religious education, even if their parents disagree with that decision, or is that just a step too far at this stage?
It's certainly an argument, I think, and one that's likely, I think, to emerge at some stage. So there are actually a range of cases. It's dealt with in the judgment at paragraphs, particularly 134 and 135. And there the Supreme Court were addressing the one point on which the Department of Education had been permitted to cross appeal to the Supreme Court, which was the fact that the judge had considered, when the judge's declaration had found a breach both of the rights of the child under A2P1, read with Article 9, and the parents as well. And what the department were arguing was that the judge was wrong to simply effectively lump the parents or lump the child in with the parents. What the court said was that no, the judge was right to do so because based on a series of convention cases, Papa Giorgio, Perovi and Lautzi. Lautzi is a Grand Chamber decision against Italy about crucifixes on walls of Italian classrooms. And towards the end of that lengthy judgment in Lautzi, the court acknowledged that, which sort of stands to reason really, that children in this context are right holders themselves. Now, obviously, for very young children, that's going to be less significant. But as children get older into their teenage years, particularly if they're older than 16, say, and for example, the law in Northern Ireland assumes that children over 16 have capacity for things like medical treatment. And anyone, I have a 16-year-old myself at home, so I know how opinionated they can be and how strongly they can hold their views. So if you had a situation in Northern Ireland where a child was asserting that they didn't wish to participate in collective worship or religious education in their school, the right to be exempted from that is still under the current legislative regime under the 1986 order, Article 21, vests that right in their parents, not in them. So they would effectively require parental consent. And it doesn't take a great leap of imagination to imagine a conflict then emerging between the teenage child and perhaps their quite religious parents who then refuse that exemption. So if you had a situation where parental consent was then required for a teenage person with capacity, then I could see there might be a strong arguable case to say that there'd be a breach of their convention rights by that limitation as things currently stand.
Yes, because that was the thought that I had, that you may have a situation where you have a non-religious child who wishes to exempt themselves, but with the right residing with the parent at this stage to be the one to make the exemption, that could lead to disagreement.
Yeah.
In the case, the department conceded that it does not inspect religious education or collective worship, and that actually intrigued me because I didn't realise that myself.
Yeah.
And do you think that lack of inspection creates a systematic risk of rights breaches, or even in itself, could that lack of monitoring could lead to a breach of the children's rights?
Yes, again, that's another. Now, the court didn't reach any conclusions on those issues because they were not germane to determination of the issues on this particular appeal. But it was very clear from the oral hearing, and obviously people can watch the oral submissions from counsel in the Supreme Court and the judge's questions and responses. It's pretty clear from the oral hearing, and it's clear from the terms of the judgment, that lack of inspection was of concern. as was, for example, the fact that ministers of religion could request information about how many of their flock effectively were in the classroom. So in a sense, it was part of this is simply that the legislation itself is showing its age and perhaps reflecting a time in Northern Ireland where there was a much greater degree of homogenous religious belief, whether that be Catholic or Protestant, which is another interesting feature of the judgment as well.
Yes, because the current framework really seems to be, the legislative framework seems to be imbalanced in favour of Christians' perspectives, and we now live in a Northern Ireland society of multiple religions and multiple cultures.
Yeah.
Do you think this judgment impacts the thinking that we're going to have in the future of how we deal with religious education and how we inspect religious education?
Yes, I think it certainly will. I know that even I think before the judgment had come out, the transferor representatives had accepted that a review of the syllabus was going to be required in any event. The current iteration is from 2007. So that's obviously that review process obviously should be informed by what the Supreme Court have set out in their judgment. Thankfully for me as a lawyer, I don't have to scratch my head too much as to what you do with the judgment. That is ultimately going to be a political judgment within the Department of Education. But just thinking aloud, I suppose there are a range of different responses to the judgment in terms of what settlement is reached. The easiest legal response, so if you were a lawyer advising the department, look, what do we do to effectively avoid any risk of further litigation in this context? Probably the easiest answer would be to say, well, look, you have a completely, you make religious education a purely educational activity in the sense that it is delivered in a way that teaches children about Christianity, but does not cross that line and teaches them to think critically about it, to think objectively about it, and that would allow. There wouldn't effectively need to be any. There wouldn't effectively need to be any opt-out or any exemption made because it would be just an ordinary subject taught in the ordinary way. So that's probably the easiest response for the department to take. Now, obviously, that would also represent a significant change. I'm aware that some commentators in this area, one I can think of, recently published a piece, a journalistic piece in one of the newspapers, David Armstrong, and he has advocated for a sort of twin track process for RE. So you would have effectively a confessional form of religious education for those who want their children to be taught Christianity, to be Christian, and then a secular form of religious education taught alongside that as well. And parents would then choose which form they wanted for their child. But again, as we were chatting before, that then raises the issue about, well, what happens when the child themselves start to assert their own rights as they get older and say, well, I don't want to be taught the confessional form, and how is that then managed in terms of opt-out? But certainly, I think the easiest answer would be to make provision for effectively a secular form of religious education. That doesn't mean, I should add, and this is clear from the terms of the judgment, that you need to give humanism, for example, parity with Christianity in terms of what you teach. The syllabus can reflect the dominant tradition in the jurisdiction, which is and remains Christianity. So you could have a syllabus that teaches, in terms of the majority of the syllabus, about Christianity, but you just don't cross that line. And if that was done carefully and properly, then there would be no need for any exemption. The difficulty is that this judgment creates, if you like, is that it's very difficult to imagine an opt-out provision that will not offend against the test, that whether it is capable of imposing an undue burden.
Just a few practical questions that I'm sure some people who are both educators and parents will be curious about. Judicial review is a measure of last resort, really. And why did the family in this case choose the route of judicial review rather than directly complaints or raising the issue with the Department of Education and the EA?
Yeah. Well, obviously there was correspondence, pre-action correspondence between the parties which raised these issues. That didn't obviously resolve the issues. The test for taking a judicial review in the particular way in which you asked the question is whether or not there is an adequate alternative remedy available, with the emphasis on the word adequate. In this case, which was always going to be centrally about the convention rights of the child and the parents, judicial review was the only adequate mechanism that could deal with those convention rights points and grant meaningful relief to them. So there wasn't really any other show in town. There were also, during the course of the early stages of the litigation when we were in court, there was an attempt at direct discussions between the parents and the school, but unfortunately we couldn't agree the precise terms upon which those discussions would take place where we had a live litigation. But it's interesting to note that the Supreme Court themselves were interested and placed some reliance on the fact that discussions had been proposed. And if you look at it's paragraphs 37 and 119 of the judgment, they considered that even the requirement to have such discussions was a problem, because it meant, again, that parents would have to either expressly or implicitly give some idea as to their own religious beliefs when discussing what they could accept and what they couldn't accept in terms of the provision that was to be made for their child.
And another thing that will be of interest as well is what makes this case significant beyond the actual individual circumstances of the child JR 87 themselves?
Well, I think there's a range of aspects where the case has a wider significance. I think the first point is that you had it's going to be, as I say, very difficult to imagine an opt-out that doesn't place or isn't capable, or doesn't place parents under this undue burden. And that then means that if you're trying to retain some level of confessional teaching within religious education, that you're always going to run up against that particular problem. The test, again, is whether or not it is capable of imposing an undue burden, not that it actually does so, just that it is capable. So you can see how difficult it is going to be to design a mechanism that doesn't offend against that if you wish to retain devotional teaching. So that the practical outworkings of that in terms of broader significance of the case is that it's going to be difficult to retain confessional type religious education. Further significance, what we've discussed around the rights of children, children as rights bearers in their own regard without having to be riding on the back, if you like, of their parents. So that's an important, it's not really a clarification, it was clear enough from the convention case law, but now we've got Supreme Court authority in this jurisdiction that says, yes, children have a right to believe or not to believe, as the case may be. More for, I suppose, the lawyers out there, they put some limits or restraints on the ULA principle or the mirror principle, which is to say effectively that domestic courts should not seek to step ahead of where the Strasbourg court is at in terms of convention principles. And that has frequently been utilised by courts to say, oh, you're asking us to go beyond what Strasbourg would permit in this particular case, and that is not acceptable on application of the Ulla principle. One of the arguments that was advanced by the department in this case was that our case offended against the Ulla principle. We were asking the Supreme Court to take a leap beyond that which Strasbourg had gone. And in short, fairly short form, I think it's paragraph 126 of the judgment, the Supreme Court said, no, there are no new principles being established. This is a fairly ordinary case in that sense of saying, look, what has Strasbourg decided? These are the principles. When we apply those principles to this case, we come up with a breach effectively of the convention rights that are at issue. So it's an important precedent in that sense that the Ulla principle itself has limits, and this case provides a very good example of those limits. Finally, wider significance in terms of collective worship. Again, as I say, it's important to recall that the declaration as issued by the Supreme Court, adopting that of Mr. Justice Colton as he then was, included the arrangements for collective worship as part and parcel of the breach that was found. Quite what the answer to that is, I'm very happy to leave to the politicians and policymakers, because you cannot, by definition, have collective worship that is objective, critical, and pluralistic. So it becomes a question of, do we have an opt-out? Or perhaps the answer to that is, if you wish to retain collective worship, is that you don't make it an opt-out, you make it an opt-in. But as I say, I'm happy to leave that to the politicians and policymakers.
Well, that's great, Stephen. Thank you very much. We've got a few questions here that have been sent in prior to the event, and a few questions in the chat. If you wouldn't mind, we'll take a few here.
Yes, of course.
So the first one is regarding the access given to external visitors and the parental right to object. What is the significance of this been mentioned in the JR 87 judgment, even though it wasn't directly relevant to the case? And what does this imply for parents considering objecting?
Yes, I think it doesn't form, quite right, it doesn't form part of the reasoning of the court. It was one of those factors, again, that I suppose, to put it in plain terms, raised a judicial eyebrow about the settlement that we have in Northern Ireland. This is not something that, as I understand it, has ever really been acted upon. This particular option has never really been acted upon in Northern Ireland, but it's clearly there for parents to consider. And yeah, it would be very interesting to see what would happen if a parent did then raise that query.
The next question that we have is in relation to the governance arrangements for schools. So are the current governance arrangements with reserved places on school boards for church representatives sustainable following JR 87?
I don't know. I suspect they probably are. There's a little, we obviously delved into it in preparing this case for the appeal to the Supreme Court. There are some very interesting books and articles on the history of religious education in Northern Ireland. And this was the fact that we have transferor representatives within the controlled sector is effectively a result of the agreement that was reached following partition, whereby the main Protestant churches agreed to transfer their schools to the state, and in return they got to have certain privileges, and that's why they're called transferor to this day, still called transferor representatives. So their position represents a historic settlement, if you like, regarding religious education in Northern Ireland, going all the way back to partition. Whether or not that could now be challenged, I think you would have to demonstrate some material prejudice by that position before you could get a challenge off the ground.
So we have another question here in relation to collective worship, and it's, what are the legal implications for collective worship? The minister hasn't announced any changes to collective worship, but it seems hard to see how collective worship could ever be objective and critical.
Yes, well, I've already said that myself. Is that it's going to be difficult, I think, to understand how you could have that. It really, I think, in terms of collective worship, comes down to whether or not you have an opt-in or an opt-out type provision. If you're going to have an opt-out type provision, then that's again difficult, because what are you going to have in place? I mean, one of the things that the judgment cast up was the fact that, so for example, in this particular case, I think there had been one child before that had opted out, but then they had returned, if you like, into the mainstream again. So this child and the appellant in JR 87 would have been the only child to actually opt out. And one of the problems that cast up, and I suspect this would be common of many primary schools across Northern Ireland, is that there simply isn't anything. There is no other provision. So I suspect that if collective worship is going to be retained and it's going to be an opt-out, then there's going to have to be something of educational value provided to those children who opt out. And that might be one answer to it. But again, you're back into the territory of whether or not having to opt your child out of collective worship causes the same kind of problems that have been identified by the Supreme Court in this case.
And we have another question here from one of our audience who, first of all, thanks you for outlining the issues to them. And secondly, how will the judgment affect schools that are religious in nature, i.e. Catholic schools?
Yeah, and I mean, this is obviously, again, didn't form part of this particular judgment. The issue obviously is that if one chooses to send your child to a Catholic school, knowing that it is overtly, the faith is overtly a part of the education, then it'd be difficult to assert a breach of A2P1, given that you made that choice. I suppose what then again, to sort of touch on something we've already talked about, it then becomes interesting is in terms of the rights of the child. Because if parents have chosen to send their child to a Catholic school, then that's obviously their choice. But as that child then gets older, and again, we can all imagine the older teenagers, 16 plus, saying to their parents, I don't wish to participate in this any longer. I'm not a Catholic, or whatever it is. And then that might give rise to difficulties within that sector as well, given the principles that we now have from JR 87. So I think it's quite possible that there could be a challenge in that context, but I think it would probably have to come from a teenage child rather than a parent, where the parent has chosen to have that education for their child.
So we have another question here, Stephen, which is, if the new RE syllabus created is objective, critical and pluralistic and has Christianity at the forefront, confessional RE has to be taught separate and led by religious leaders. Is that correct?
If that is the effect of the new syllabus whenever it is produced, I know that some have raised concerns about the makeup of the body that's been charged to develop that new syllabus. If that is the case, well, one, there wouldn't need to be any opt-out, because it would just be another educational subject, and you would have no right. In fact, if it was taught in that way, critically, pluralistically, objectively, you'd have no case to make for an opt-out, because you can't opt your child out of studying history, you can't opt your child out of studying maths, and it would just be taught in the same way. So it would deal with the opt-out issue. Whether or not there then needs to be space for some form of confessional religious involvement in the controlled sector, yeah, I mean, it's quite possible then that you could have a separate provision made, effectively driven by the churches. Now, that then begs questions as to, well, okay, should that be during the legal school day? I know, for example, we had obviously looked at research in other Commonwealth countries, and I think the position in New Zealand, for example, was that they sort of formally close. They provide some form of confessional religious teaching to children, but they do it when the school is actually formally closed. So it's not part of the legal school day. So that might be an option for churches going forward.
We have another question here, but I think you've already touched on this a bit, but just for completeness. Faith formation is a synonym for indoctrination as defined by the Supreme Court. Does that mean that faith formation cannot remain the default type of RE in maintained schools, and that it will need to move to being opt-in as a separate option alongside a default objective, critical and plural track?
Well, I think, as I say, the position in respect of maintained schools is a bit different from controlled schools. And one does then get into an interesting debate. Again, I think there's been some media about this, as well as the fact that the controlled sector has historically been, quote unquote, the Protestant educational provision in Northern Ireland. There may then become some degree of disparity between the two, because, as I say, I think the Catholic maintained sector is in a somewhat different position in that parents will be choosing that particular religious expression for their children.
And we've just time, I think, for one more question, and this one is really around choice. And it's really that in Northern Ireland, the majority of schools are Christian in nature, and that parents don't really have a choice to send their child to a school other than one that has an explicit religious character.
Yeah.
Is this something that needs to be addressed by the authorities moving forward?
Well, that's right, in that the legislation effectively provides that really all education in Northern Ireland has, to put it at its broadest, that form of kind of Christian ethos, if we can put it like that. I'm not sure that that's necessarily objectionable per se, so long as the experience of children on the ground conforms to what the law requires. That has been the needle, if you like, has shifted a little bit because of the JR87 judgment. And as I say, it's then really over to the politicians and the policymakers to work out what kind of education. But I mean, why I think in the immediate aftermath of the judgment, there was quite a lot of adverse publicity and comment around it from certain sections of the public. And I think the reason for that is because it does touch upon important, much broader issues that we are all kind of dealing with in society, which is what should be the role of religion in our society. Obviously, in Northern Ireland, we have had a particularly difficult and sectarian divide, even within the Christian religion, and what role, if any, should religion play in our education system? What's the role of religion and the state? So, for most people nowadays, our starting premise is that the state, religion is a quote unquote a private matter, and the state should have nothing to do with it. But actually, if you look historically, even if you look at somewhere like England, we see that religion is still very much part and parcel of the state system in England. The Church of England has its bishops and House of Lords. The monarch is the head of the Church of England. So these are obviously much broader issues, but it's not, there's no easy answer, I think, to that particular question.
Well, Stephen, thank you very much indeed for giving us your time today to discuss this very interesting and important case. We hope that everybody that joined us today got something from the seminar. It just remains for me to thank all of you for joining us today, and to, as Paul says, put a shameless plug out that there is a QR code and a link in the chat function for future training events run by the Children's Law Centre. So please feel free to make any inquiries directly to Paul about those. And Stephen, thank you very much indeed for joining us, and we hope to see you all again sometime soon.
Thank you very much, Eamonn.